Good morning and welcome to the Read Longyear, Malnati, Corwin, and Burnett February webinar. My name is Mike Longyear. I'm one of the senior members of the firm, and I'd like to welcome you and thank you for joining our program today. For those of you that are familiar with the firm and those of you that are new to the firm has been in Seattle since 1956, and we're a general civil practice firm, which means that we do a variety of work working with individuals and families and businesses, from doing real estate and business law to estate planning and family law and related things in between. Today, we're going to be hearing from four of the younger attorneys with the firm, if you will, and delighted that they're going to be sharing their experience and expertise with you on topics related to their practices, but also those types of situations that individuals and families face in addressing the needs for their families and that sort of thing. Our format today is going to be having each of the speakers present for about 12 minutes. And if you have questions, which we welcome questions, if you could put them into the chat, and then at the end of the program, end of the presentations, we'll take some time to answer those questions. We're always available for questions and to discuss. You can go to our website and contact us, or of course call as well. And the goal of these webinars is not to, basically advise as to individual or particular circumstances, but to give some general overview of the legal issues and the types of situations that individuals and families deal with, and have some consideration and maybe do some proactive planning to consult with our team of attorneys to address issues ahead of time, so that things that might become a crisis or problematic down the road can be planned for. Emphasis on planning and taking the steps to put a plan together and understand what the legal rights and interests are and the opportunities for planning as one looks at the future and the types of goals and needs of individuals and families. So I'm a little bit ahead of myself, but I think that's okay. It'll give us a little more time. So I'd like to present our first speaker, attorney Carla Calogero. Carla is a member of the firm, having joined the firm in 2014. She actually was first with us as an intern during law school. So we're really delighted to have Carla with us. In addition to her law degree, Carla also has a master's in bioethics, which informs her practice and her work with the clients, particularly on advanced care and end of life and estate planning. Her practice areas, of course, include elder law, probate, trust, and guardianship, as well as estate planning. She's a member of the executive committee of the elder law sections of both the Washington State Bar and the King County Bar and the Estate Planning Council of Seattle. She's also been honored as a super lawyer rising star in elder law by her peers in 2015 through 2020. So I'll let Carla get started. Thanks, Carla.
Thank you, Mike, for that great introduction. And I'm so happy that all of you are here with us today. My presentation is on the options for the disposition of bodily remains in Washington State. Our options have expanded in recent years, as we'll discuss. There are a few statutes that concern the disposition of bodily remains in Washington. We do have the Uniform Anatomical Gift Act, which concerns organ donation. In terms of the options that we'll discuss today for disposition of final remains, statute RCW 6850-110 provides that bodily remains must be buried, undergo cremation, alkaline hydrolysis, or natural organic reduction. That was the law that became effective in 2020 that expanded our options. There's a statute that provides that you may name an agent to follow through with your instructions regarding the disposition of your bodily remains and make any anatomical gifting and so forth by the agent. And then we wrap it all together for you in a document we prepare for you called the Declaration Regarding Disposition of Remains that provides for any anatomical gifting, the disposition method, and designation of your agent. So the first method we'll talk about, you're all familiar with. It's traditional or conventional burial. It's also termed whole body burial or earth interment. And the process, as you're familiar, is that the whole body remains are chemically disinfected, usually embalmed in embalming chemicals, laid in a coffin and interred in the ground, often in a cement vault or cement slab. In terms of the duration of decomposition in traditional burial, it's usually 5 to 10 years for decomposition of the organic material of our body, and that's just to skeletal remains. And in terms of the cost, there's a wide range of costs for traditional burial. Some of the lower cost options are just for immediate burial, which means no ceremony, no fancy coffin, and then all the way up to 10,000. And really the sky's the limit. Of course, any fancy caskets or burial plots in a designated area or headstones are all in addition. So our cost range is about $1,300 to, again, the sky's the limit. The final disposition is in a cemetery, either in a grave burial or entombment in a crypt in a mausoleum. And generally, traditional or conventional burial is the method that does have the greatest environmental impact in terms of taking up land, in terms of the chemicals, in terms of the release of gases into the air, and so forth. All right, the next option is green burial. And other terms for green burial are eco-friendly burial, natural burial, or direct burial. And in green burial, the whole body remains, meaning after any anatomical gifting, are placed in either a biodegradable shroud or container, a simple wooden box, and interred in a grave for natural decomposition. There's no chemicals, no embalmment. And the cost is right now in Washington around $3,000 to $4,000. Excuse me. And the final disposition, as I already mentioned, is in a natural burial ground. These are designated cemeteries or burial grounds for natural burial. There's a few in Washington, although none in Seattle proper. And green burial does have less environmental impact than traditional or conventional burial. The third method for disposition of remains in Washington and all over the world, of course, is traditional cremation. And we call it traditional cremation because we'll talk about another method of so-called cremation in a moment. But this is also called flame cremation. And of course, the process involves the incineration of whole body remains. The duration of the process of incineration or cremation is about 2 to 3 hours at extremely high temperatures. And what comes out of the cremation process are several pounds of cremated remains. We also call those cremains, and that's bone fragments and ash. And traditional cremation also has a range of costs, but starts lower at around $800, and it is generally the lowest cost option for final disposition of remains, other than the willed body program, which we'll talk about in a moment. In terms of the final resting place, if you will, of the cremains, there are several options. They can, of course, be buried in an urn in a cemetery, or in a columbarium, which is a structure with urns in it at a cemetery. Of course, cremated remains can be dispersed or scattered at your instruction or loved one's preferences. Your cremated remains can be made into jewelry or artwork. They can even be combined with cement and used to create artificial coral reefs. There's less environmental impact with traditional cremation than traditional burial, but it does still have a, I guess I'd say, a more substantial environmental impact than couple of alternate methods we'll discuss next. It is the most common method of disposition, or most chosen method of disposition in the United States. Natural organic reduction. This is sort of all the buzz with new laws in 2020. And this is also called human composting. So we've probably all read some articles about human composting. It also is termed terramation and soil transformation. And in human composting, the bodily remains are in a contained, accelerated conversion to soil. And what this means is that the whole body remains are placed in an individual vessel, sometimes called a pod, with your natural microbes and also some organic matter like mulch or wood chips or alfalfa, and oxygen flows into the vessel to aid the decomposition process. It takes about 1 to 2 months for decomposition to occur in the vessel, and yields about 1 cubic yard of soil. This is about enough to fill up a flatbed of a truck. But then it is also cured and rested for a few weeks to complete the process, still with that amount of volume of organic material. The cost is between $5,500 and $7,000 currently in Washington State. And in terms of the final disposition of all of that soil that contains you, it may either be returned to your designated agent, or it could be donated for contribution to reforestation efforts in Washington State, for example. And human composting definitely has less environmental impact than traditional burial or flame cremation. There are no direct emissions of greenhouse gases in natural organic reduction. The other new option, relatively speaking, under the law is alkaline hydrolysis. And this is also termed liquefaction, aquamation, biocremation, or flameless cremation, as compared with traditional cremation. And in alkaline hydrolysis, the full body remains are placed in a large vessel, and heat and pressure and water and some base chemical agents are added to the vessel. And what comes out is bone fragments and a lot of liquid. The duration for alkaline hydrolysis decomposition is a matter of days. It's relatively inexpensive. The cost currently is around $1,500 in Washington State. And what comes out of the process, as I mentioned, are some bone fragments, and a lot of organic liquid. This is great organic liquid. So it can either be provided to the agent or some of the facilities use it as fertilizer. Some just flush it or pour it down the drain into the sewer system if there's no other instructions. And like human composting, there's a very small fraction of the environmental impact of traditional burial or flame cremation. No direct emissions or greenhouse gases with alkaline hydrolysis. And the final option for disposition of bodily remains in Washington state is whole body donation to a medical school. There are two programs in Washington, the University of Washington Willed Body Program and Western State Washington Willed Body Program. There's a lot to understand about the process. The donor must complete the registration form and submit the form to the program prior to death. So each of the programs have a rather substantial registration donation form that must be completed before death, as I mentioned. And then upon death, the program must be contacted immediately and the body delivered or transported to the medical school as soon as possible. This means that whole body funeral service would not be possible with the whole body donation to the Willed Body program. In addition, no organ donation or anatomical gifting is allowed if you're willing your whole body to one of these programs. And it's important to know that even if you've made the donation and pre-registered and are looking forward to your body being used for medical school and health education, the program may reject any donation after death. So it is critical to elect an alternate option in your declaration regarding disposition of remains. So we would just draft that document to indicate that you had completed the whole body donation program application form with the respective institution. But if your body was rejected, then, for example, you may wish to have human composting. Happy to answer questions, and there may be many. One more slide, actually. The process takes 2 to 3 years, meaning that the medical school may hold your body from anywhere from 2 to 3 years. The good thing about this is that there's absolutely no cost to the donor. All expenses are paid for transportation of the body. And the final disposition would either be cremation or traditional burial. The cremated remains could be returned to the agent, or whether cremains or whole body burial, those would have a final resting place at the community burial ground for each program. Thank you.
Great. Thank you, Carla. And I see that some questions have come in. And just a reminder that we'll be doing the Q&A at the end of the presentations. And just to keep on schedule, I'd like to introduce our next speaker, Attorney Kristin Kelly. Kristin practices both in family law, but also in business transactions, including trademark. And she joined the firm in 2019, graduate of Seattle U Law School. Prior to law school, she worked for several years in different capacities in law firms. So she's very familiar with lots of the many areas of law and brings with that experience, insights into working with her clients. She's going to be talking about community property, which Washington, of course, is a community property state. It comes up not only, of course, in the family law context, but in the estate planning context. So delighted to have Kristin address this important issue. Kristin.
Thank you, Mike. On the coattails of that, I will not be providing any kind of legal advice regarding what happens to community property upon death, only upon divorce or separation. of parties. Hello, everyone. I'm Kristin Kelly. I'm an associate attorney here at Reed Longyear, Malnati, Corwin, Burnett, and I'm here to talk to you about community property, the presumption, the common misconceptions, and potential exceptions. Next. As many of you may know, Washington State is a community property state. Essentially, what that means is that income earned and property acquired during a marriage is owned by the marital community itself. Next slide. When a marriage ends in Washington and the parties want to divide their property, the court will presume all income earned and all assets acquired during that marriage is community property and community debts. And the court has the authority to divide that property between the spouses. While this may not be news to most of you, one thing you may not be aware of is that community property can be created by two parties who are not married but are living together in a marriage-like relationship. The term used for this in family law court is a committed intimate relationship. Many people are shocked to learn at the end of a very long relationship where the parties never married but lived essentially like they were, one of the parties can file a petition with the court asking the court to divide the community property that was created and divide it equitably between them. Next slide. In my practice, I meet with individuals at all stages of their life and relationships. I meet folks when they are planning to get married and want to negotiate how community property will be created during their relationship. I meet with people simply who have questions about protecting their separate property before or during their relationship. And I meet with people at the end of their relationship who are trying to understand what happens next. Will they be okay? Will they be left with nothing? In these meetings, I have found there are a lot of misconceptions around how and when community property is created and what will happen to that community property upon divorce. One such misconception is that when you get married, all property automatically becomes community property. This isn't true. If one party owns a home when they marry, that home does not automatically get converted to community property just because they said I do. If a party owns a car prior to marriage, it's still that party's separate property after the marriage license is signed. There are some ways these assets could eventually become community property, or that the community could potentially create an equitable interest or lien in this property, but the marriage itself does not automatically convert property into community property. Along the same lines, folks often think that if one party's name is on a deed or a mortgage and not the other, it's not community property, or conversely, that if their name is on a deed or a mortgage, it must be community property. However, title does not control whether or not the property is community or separate property. Whether it's community or separate will be determined by the court despite title, and the principles we're talking about today will have much more bearing on how that determination is made. Another misconception is that the court can't touch your separate property or your spouse's separate property. This is also not true. While the court doesn't make a regular habit of awarding the separate property of one party to the other, the court does have jurisdiction over all the property, community and separate, of both parties. And if the court believes it's necessary for an equitable division, it can award separate property of one party to another. I bought it with my money. This is generally a misconception and probably the most common one I encounter. Many people believe that their income is their own separate property. More and more couples these days are keeping their finances separate, their income separate, or have a community account, a joint account, and a separate account. They come to me saying, I paid for that with my money. The problem is, unless you have a relationship contract where both parties agreed in writing that their income would be separate property during their marriage, it's not. It belongs to the community. Their employment benefits too. It doesn't matter who worked harder, who earned more income. It's all community earnings and community assets. Another misconception is that community property means that the court must divide property 50-50. While that very well may be the case, it is not a hard and fast rule. The standard the courts use is actually fair and equitable, which is not the same as equal. Sometimes the court will award a disproportionate share, which is anything other than 50-50, of the community property if that is what the court believes is fair and equitable. There are many potential considerations that the court could rely on to award a disproportionate split of the community property. Next slide, please. One example is when one party has a significant separate property interest and the other party has no separate property interest or a very small separate property interest. The court could decide that one party gets more of the community property because the other party has so much of a separate property in order to make it an equitable division. Another example of when a court might award a disproportionate share of community property to one party is if the court determines that one party has dissipated or wasted community assets, leaving less for the community to divide at the end. In that case, the court might award more of the community property to the party who did not waste community assets. The court has done this in cases where one party wasted community assets on extramarital affairs. They've done it when there's gambling and also alcoholism. Though I will point out that this case is much less common and is reserved for pretty specific cases. Another reason may be because of the nature and the limitations of the assets. Maybe it's not feasible to divide the property exactly 50-50. An example of this may be that the largest asset of the community is a home, and one of the parties is raising the children in that home. So the court decides it's not equitable to force them to sell the home for an equal split of the property and awards the home to the party who's raising the children in it. Other considerations the court may rely on in determining what is fair and equitable. The length of the marriage. Courts treat marriages, short marriages, and long marriages very different when it comes to dividing property. Future earning capacity of the parties. The court will take into consideration whether or not each party is able to provide for themselves at the end of a marriage and their ability to earn more in the future. Assistance in putting one spouse through school. The contribution of separate property funds into the community that's being divided. And professional educations or licenses acquired during the marriage. The court will often want to make sure that a marital community receives sufficient compensation for the investment it made into that party's career. Next slide. Now, just because there is a presumption that everything acquired during the marriage is community does not mean it actually is. There are several exceptions to this very general rule. Essentially, it's each party's job to demonstrate to the court how and why certain assets or income are not community property, but in fact their own separate property. This is by no means an exhaustive list, but some exceptions to the presumption include an inheritance received by one of the parties. If one of the parties receives an inheritance to them individually from a friend or a relative, and they can show the court that those funds or that asset have stayed separate since they received it, has been kept separate from the community, the court will generally find that it is the separate property of that party. Similarly, if one party receives a gift solely to them, and they've kept that asset or those funds separate from the community, and they can demonstrate that for the court will generally find that that's the separate property of that party. As I mentioned before, just because a person gets married does not mean their property automatically becomes community property. So neither do the gains on that property or profits and rents from that property. So for example, if a person came into a marriage with a home they bought previously, and they decided they were going to move into a new home with their new spouse, and they just rent out their old home for 10 years. And at the end of that 10 years, the parties separate. The increase on the value of that home and rents received, if kept separate, would potentially be separate property if that party can show to the court that it was kept separate. Next slide. I think that's all the time I have today, but here are the takeaways. Community property is property acquired during a marriage or a committed intimate relationship, and the court can fairly divide that property at the end. The court considers many facts when deciding how to divide property fairly and equitably, and it may not mean 50-50. If you want to establish how community property is created in your relationship, you can negotiate that in a relationship contract so that there are no surprises later, whether it's entering into a committed intimate relationship or a marriage. And finally, keep your separate property separate and keep your records. Thank you so much.
Mike, you're on mute.
Thank you, Kristin. That was excellent and good reminders for both family law and on the estate planning side. We're going to introduce our next speaker, Greg Porter. Greg joined us during the pandemic in 2020, a graduate of the University of Washington Law School. Greg practiced in a litigation firm before he joined us and brings those litigation skills to us in a variety of areas. And we get to work together on a couple of pretty interesting cases involving both conservatorship, guardianship, and community property. So Greg is going to jump in on that topic. And again, I'll hold your questions till the end, but put them in the Q&A. Thank you. Greg, you're muted.
All right. Hey, good morning, everyone. And thank you for introducing me, Mike. As he said, my name is Greg Porter. I'm a litigation associate at Longyear. And as a litigation associate, my expertise is less so in planning, but more in unraveling and solving problems as they arise. And my talk sort of curtails nicely off the community property discussion and looking at a very specific circumstance. And that is when you have a community estate, so people who are married, but one of the spouses is in a conservatorship or guardianship or both. So you have this community property, as Ms. Kelly so nicely laid out. So what happens with that community property once one member is in a guardianship or conservatorship? Who handles that community property? And as the other said, I'll forewarn you that the best I can give you are general rules and guidelines. Individual cases will vary, and just assume that any general rule I present to you has a big asterisk at the end of it. Your particular case will depend on the parties and the judicial officers involved. So to summarize what Ms. Kelly said, community property means that both spouses have the right of disposition over the entire community estate. So as she said, it's not that each person owns 50% of the whole. Each spouse has the right of control and disposition over all of the community estate, and that power is shared with the spouse. And then looking at the conservatorship statute, it says that a conservator has the power to collect, hold, and retain the property of the person subject to conservatorship. And so an open question might be, does that mean the conservator now has that same power of disposition over the community that the spouse had? And the answer is no, or perhaps not exactly. When a spouse is subject to a conservatorship, their conservator does not necessarily have the power of disposition over the community estate. And in fact, what happens is that the other spouse outside of the conservatorship is usually appointed as the custodian of the entire community estate. And so rather than the conservator fully stepping in the shoes of the spouse subject to conservatorship, instead the other spouse will manage the community, and oftentimes the conservator is either assigned to control only the separate estate of the person subject to conservatorship, or they're given very specific, very limited control over parts of the community estate. And this becomes interesting. Say you have a marital community and it's undergoing separation at the same time that one spouse is subject to conservatorship. Because the fact that one spouse is custodian over the entire community estate still holds all the way up to a final divorce decree. Washington law is that you're not divorced until there's a final decree. Even if both parties intend to be divorced, you've drafted up all the documents, all that's left to do is sign it and get the judge's signature, you're still married, and all the marital rights still exist up until that final moment. With a notable exception being that if two spouses actually draft a robust final separation of their property, awaiting a final divorce decree, that will sometimes be good enough to break up this presumption that this one spouse is custodian over the entire community. An example of that was the Washington State Supreme Court case In Re Estate of Patel, where the parties were awaiting a final divorce decree, and they entered a contract saying that this was a complete and final settlement of all marital and property rights. And they never actually were able to get the divorce decree because one of the people died before the final decree. But based on this contract and its robust language saying this is final, this distributes the estate, as that was good enough to determine that spousal rights had been officially waived. But absent language that specific and that robust, up until the final moment of a divorce decree, the community property holds, which in the cases of guardianship and conservatorship will mean that the other spouse is still the custodian of the community property up until that divorce decree. And that might make the conservator uneasy, especially in cases where people were together for a long time. So the community estate is most of the estate, and the separate estate carved out for the conservator might be very limited. It might not even be enough to sustain the person subject to conservatorship. And so how does the conservator provide for the person subject to conservatorship in that situation? And the easiest answer is diplomacy, because the conservator is not the spouse. So even if there was animosity, even if the relationship was frosty between the spouses, once the conservator comes in, they might be able to reestablish diplomatic relations, so to speak, with the other spouse and come up with an agreement to share some community property. But if diplomacy fails, then the conservator can go to the family law court, appear through their own attorney, which they have the right to do, and they can request an award of maintenance or pre-separation distribution. And they can cite the fact that perhaps most of the value is in the community state. And so without access to community funds, they can't sustain. They can't provide for the person subject to conservatorship. And in our experience, that's a compelling argument that the family law court is usually willing to provide maintenance in that situation. Now, another thing to consider is that when someone is subject to a guardianship or conservatorship, the statute says that they are the person who represents in any litigation. In fact, the statute says that a person subject to guardianship can only sue or be sued through their guardian. And so when you have that circumstance where there's a concurrent separation and guardianship matter, then that means it's the guardian or conservator who's actually the party who litigates and resolves the separation matter. But the guardianship and conservatorship statutes also say that someone subject to a guardianship or conservatorship has the right to independent counsel. So an attorney separate from their guardian's attorney or conservator's attorney. And to be frank, the explicit purpose of providing that separate attorney is really to disagree with the guardian or conservator and their attorney, as if the person subject to guardianship or conservatorship has different wishes, has a different intent than the guardian or conservator. They're allowed to have an attorney to represent their wishes. And so you get to thinking, well, that's specific for the guardianship matter before the guardianship court. But does that mean that the person subject to guardianship can bring their separate attorney, their individual attorney, into a concurrent separation matter? Because after all, if they disagree with the guardian, in the guardianship matter, then it's foreseeable that they may also see things differently than their guardian in the separation matter. So can they bring over their separate attorney? And the answer, at least so far in King County, is yes. Someone subject to guardianship or conservatorship can get their own individual attorney appointed in the guardianship matter, and then also have a specific attorney for them appointed in the family law matter as well, to represent their specific and perhaps different wishes in the separation matter than their guardian. And so how does this work? And so this will be a bit technical, but it's sort of the way we've found out how to navigate. You have these concurrent matters, and an order in one matter does not automatically become an order in the separate matter. So if someone subject to a guardianship wants their own attorney in a concurrent separation matter, how do they do that? And so step one is that there is a guardian or conservator appointed. Because if it's just a petition, if there is no guardian yet, then the law has a presumption of capacity, which means the person just automatically has the right to their own attorney in the separation matter. But once a guardian is appointed, then step two is to get counsel appointed for the person subject to guardianship within the guardianship matter. And you can use the statute cited earlier. It's a right that someone has in a guardianship. And so it's pretty straightforward to get counsel appointed, usually. And then the next step is, while still before the guardianship court, while still in that matter, ask that court for an order authorizing the appointment of individual counsel in the family law matter, and rely on the same statute that you did to get counsel appointed in the guardianship. Say that if I have capacity to direct an attorney and receive legal advice pertaining to my guardianship, then I also have that capacity with relation to the separation matter. And then once you have that order from the guardianship court saying you have a right to counsel in the separation matter, bring that over to the family law court and present it to the family law judge. Because the order in the guardianship court does not just automatically become an order in the family law court. And so this last step may seem duplicative, but we found it's very valuable. Basically, it gets the family law court and the guardianship court on the same page. It opens up that channel. And so if there's any disagreement, if there's any discrepancy about whether there is that right to counsel, at least the family law court has signed on and bought into the process. And my last topic for today also pertains to an aspect of separation matter, and that's if there are children involved, which means that the family law court needs to come up with a parenting plan. So if someone is subject to a guardianship, and now I'm going to be more specifically discussing just guardianship and not including conservatorship, does the guardian come up with a parenting plan, or does the person subject to guardianship come up with a parenting plan? And if someone is in a full guardianship, then in our experience, it's the guardian who will actually come up with the parenting plan. But when you have a limited guardianship, which means that there's a finding of capacity as to some things but not others, the way the law works is that if the guardian is given specific authority, that's their authority. And if nothing is said on the matter, then the person is presumed to still have that capacity. So when someone is in a limited guardianship, they're the one who will come up with the parenting plan in the separation matter, unless the guardianship court has specifically said that it's the guardian who will come up with that plan. And I think that's all my time for today. So thank you all very much.
Greg, thank you so much for taking us through that process. It's as we know, it's complicated, and hopefully clients that find themselves in those situations will seek legal advice to guide them through it. Our next speaker is attorney Meng Yu. Meng joined us in 2021. He's a graduate of Seattle U Law School and also the University of Washington LLM program in tax. Prior to law school, Meng worked in technology, variety of roles and capacities, and so he brings that expertise and experience with him. And Meng is going to be talking to us today about probate assets, non-probate assets, and how planning works around those types of assets. So Meng.
Thank you very much, Mike. Good morning, everyone. I'm attorney Meng Yu, and my practice area, as Mike referred, includes estate planning and probate. Now, this has given me the unique perspective on many types of different probate assets, what usually pass pretty quickly versus ones that are a little more complex and may require a little bit more help. and forethought. And today I'll be sharing some general information about potentially problematic probate assets that may require that additional forethought when completing an estate plan, and share some general tips and recommendations for planning opportunities. Now, what many clients are not aware of, unless they have administered a probate themselves, is that a significant amount of time in probates can be spent during the inventory and distribution phases of a probate. Now, an inventory is actually required under Washington statute, specifically RCW 11.44.015, which is currently on screen right now. And this is one of the things that is really surprising to most people, is that within 3 months after appointment, a probate administrator, personal representative, or executor for an estate is required to make a true inventory and appraisement of all the property of the estate, including a list of all liabilities, encumbrances, liens that are owed by the estate. And everything must be valued as of the date of death of the decedent. And now, for most traditional and common assets, completing an inventory and subsequent distributions of the assets is usually not an issue. However, when non-traditional or uncommon assets are part of an estate, additional time, energy, and costs may be incurred by the personal representative to complete the inventory not only on time, but then further down the road to actually distribute those assets to the necessary estate beneficiaries as well. Now, here are some examples of potentially problematic probate assets that we've witnessed in the, at least I witnessed in the past several years. The first category here is non-readily identifiable property. And the gist here is pretty straightforward. If it's not easily seen or known about, usually these types of assets can be missed. So the first item on example here is Bitcoins, altcoins, or other types of electronic currency, which have really come into the foreground in the past several years, especially with the adoption of blockchain technologies and the proliferation of all these different types of coins and NFTs, non-fungible tokens. Everyone's just been jumping on the bandwagon, it seems. However, because of the fact that they're non-tangible, it's not as easy to determine where that these assets currently reside, how much they are, and who actually owns them, unless you actually have the information available. Next are precious metals. This would include bullion or certificates of exchange, metal coins such as gold coins or silver coins. And again, a lot of these, because of the nature of the asset, just may not be physically available or even known to most estate administrators. Next is intangible property, which is one of the largest categories here, and similarly to electronic currencies, in recent years has increased dramatically beyond the standard areas that have been considered intangible property, which are typically copyrights, trademarks, closely held business interests, and stock options, to now include internet assets, which we're seeing now, such as domain names, social media accounts. If anyone's come across social media influencers, a lot of their accounts are now worth considerable amounts of money, not only on different platforms such as Facebook, but YouTube, as well as Instagram. And so how do you sit there and track these things and know about them if you're not someone who's following these individuals or know about these particular assets? And then last are collectibles. These can include rare books, expensive jewelry or costume jewelry, fine art, trains, or other types of memorabilia, which, if they're not readily known by individuals who may be going through a person's estate, how are people to know that a specific rare book is actually worth thousands of dollars in someone's library compared to another book sitting right next to it that may be only worth, $5 or $10. And then also are if any of these collectibles are actually contained in a secure storage facility, such as a storage locker or other temperature controlled location. Do people actually share that information as to the location and where these items are actually located? Next is foreign property. This is one of the things that we are seeing so much more of recently and has become more prevalent, especially with the increase in remote work opportunities that allow people to now work in far away areas. And this has allowed them to now start to look around and potentially purchase real properties, such as timeshares, condos, houses in far-flung locations, and then even potentially renting them out as Airbnb locations and obtaining profit there as they continue to live this digital nomadic lifestyle, as well as business interests. So sometimes people may want to sit there and purchase a pub or a restaurant or other types of mineral or interests in other locations. And so again, because these are located in far-flung locations, it's very tough to sit there and know about them, especially if someone's trying to administer a estate, not let alone if they value these types of assets, especially if there's complicating factors such as a different native tongue is being spoken in those locations. And last is restricted property, which usually relates to property or assets that have specific government regulations that apply to their purchase, sale, and ownership. The most common example being firearms that have purchase, transfer, restriction, and requirements, but also this includes other types of items that may not be something that is thought of, such as endangered species animal products, or other contraband products such as controlled substances, which require special licenses or fees to be paid. Now, after reviewing those examples, one of the ways that we go about viewing the inventory and subsequent distribution process is looking at it through the lens of a third party. And that's something that I was hoping was coming through here, is like always thinking about it from the perspective of a third party who's going to come in and actually have to now inventory all those assets and value them. And so if they're unfamiliar with a person's assets, it's actually a lot easier then to identify potential problematic assets, usually by first asking the question of if there's any special knowledge or resources that may be required to identify and access any particular property. For example, does a personal representative know the location, have the proper access to the asset? A great example here is a safe deposit box located in a specific bank that is a specific branch location and may have a specific access control list as to who can actually access it, and may require a key to access as well. If not, then that may be a significant pain point that needs to be addressed through planning. Now, this is especially important if dealing with electronic currencies that may have their associated wallet, which is how most electronic currencies, Bitcoins as an example here, are associated in the blockchain is with a specific wallet. If that wallet is not contained on an exchange, i.e. a third-party platform, and instead someone has decided to maintain that storage wallet on a computer or other storage device and potentially secured that with some sort of authentication mechanism. If that is not readily available or even accessible to someone who is administering a estate, that could definitely cause issues because the asset could then be overlooked or may be considered a total loss. Also, special jurisdictional requirements can be an issue. For example, if a person passes away with real property holdings in a foreign country, there may be a specific transfer process for that jurisdiction and asset type. A relatively recent example that we've come across has been how different jurisdictions treat timeshare interests. One country it may treat the timeshare interest as expiring upon the death of an individual, whereas another country and or local state may sit there and treat those timeshare interests as real property interests that then require to have a ancillary probate in that particular jurisdiction to be started to transfer that timeshare interest. So again, these are the types of questions that can arise based upon different locations, different types of assets. And here was a great example of same asset, but different jurisdictions and rules. Next is ease of valuation as of date of death. And if there's any assets that have very specialized appraisals or marketplaces, are there specific appraisers or standard valuation processes that should be used? For example, for a classic car, usually most people try to use Kelley Blue Book or NADA to value vehicles in an estate. However, with classic cars, it may be more beneficial to establish fair market value as of date of death by going through a dealer who specializes in classic car sales. Similarly, documented provenance can be key to helping an expert establish authenticity and valuation quickly. Not only does this arise with fine art, but also with unique items such as covered animal species products that are considered endangered. Third, and often overlooked, are if specific maintenance requirements to maintain an asset, such as specialized insurance, professional custodians, or regular service and upkeep fees are required. Think of musical instruments that are antiques that need to have a specific temperature-controlled environment or be tuned on a regular basis. These identification processes lead to some common proactive planning recommendations. First is research and identify valuation and transfer methods, while people are living. Obtaining expert advice to facilitate contemplated transfers. For example, if someone owns a timeshare, next time they go visit, maybe potentially go talk to the timeshare office to ask them, hey, if I pass away, what happens to my timeshare interest? And kind of collecting information in that that path. Next is actually documenting that information down into something such as a summary of assets that include not only custodian, location, other identification information, as well as authorized individuals that may have access to that particular asset, as well as documenting security information that may be required, locations, passwords, as well as collecting documentation in a centralized location to establish provenance for a particular asset if that's something that's typical. And last is sharing this information with any fiduciaries that you nominate in your estate planning to make sure that they're aware of the location of this information and confirming that they can actually go access it if the need ever arises, as well as sharing any changes, because a lot of times with collectibles, people buy, sell, gift assets. And so you want to make sure that your documentation is being updated and that you're sharing these types of changes so people don't go on wild goose chases, trying to go locate assets that were originally they think still exist in your estate. And so as I come to the end of my presentation here, I really want to make sure that the key takeaway here is that with proactive planning, individuals can influence to a large degree how the inventory and distribution process occurs, even with complex assets in their estate. Now, this concludes my presentation, and I thank you all for listening. Mike?
All right. Meng, thank you so much. That was really good advice and very informative. And as someone that practices in the probate trust administration area, it is so much more efficient and helpful when there is that documentation and some of those proactive steps are taken before a person passes away. So we do have some questions that have come into the Q&A, and I'm going to jump in there and start. There was a question about living trust, and although we did not discuss living trust in particular today, I think Carla and Meng and I, practicing in the estate planning area, are all familiar with this question. And Maybe, Ming, do you want to address why living trusts in Washington are different than living trusts in California? I know you're not licensed in California, and Tom Hawthorne is, but I think we're familiar enough with that issue. So,
Yeah, sure, Mike. So in California with probates, there are percentages of the estate that are paid out for probates down there. Conversely, in Washington State, with probates, there's no specific percentage that's paid out as a part of the probate for for the administration. And so that's one of the big key differences between probates in California, which people try to avoid by having living trust and then bypassing probates there, compared to Washington, where it's relatively cheaper in terms of the amount of fees and the overall expedited process, which is much more efficient in Washington in regards to probates. And as stated earlier, there's less onerous fees that, and in terms of percentages that are actually needing to be paid out.
having commented on the fee portion, we also sometimes do revocable living trust if there is particular separate property, or there may be privacy concerns where the client doesn't want the distribution of the estate, which would be part of the public record of the will that's filed in a trust, which may end up being a public record, but generally starts out not being filed with the court. And the same types of tax planning and distribution language can be included in both a will and a living trust, for the type of marital and exemption trust that many of our clients work with. So Carla, any other comments on that, on living trusts?
No, I think you both have covered the points. It's a question that we get often with people listening to sort of national commentators about how awful probate is. So we're very accustomed to discussing the pros and cons of a living trust and last will.
Okay, very good. So there's a question about investments, and we're not investment advisors, so I'm going to pass on that, but we would be happy to talk to individuals about planning, and can maybe give some tips on finding an appropriate investment advisor. Carla, a question specifically for you. Options on donating whole bodies to medical colleges. I think you touched on that. Any additional comments that you want to add?
No, I'm reviewing the questions that came in on this topic from one of the attendees, and it looks like there was a follow-up question. Are there a dearth of bodies at the World Body programs? And I know that a couple of years ago, there was a shortage of bodies that had been donated, and some medical schools like Eastern Washington Medical School was unable to borrow from UW or Washington State and had to borrow from California. I think it's probably an ebb and a flow, and of course, we never know when one's body might ultimately be willed. But I'm not aware if there is currently an oversupply at this moment.
And then could you comment on the distinction between the donor designation on driver's license versus the whole body donation?
Certainly. So the donor designation on a driver's license pertains to potential organ donation only. Whole body donation can only be accomplished through these contracts with the respective willed body program, not through any organ donation on the driver's license or any other document. In our declaration regarding disposition of remains documents, we provide for authorization of a variety of anatomical gifting. So yes, organ donation, tissue transplantation, medical research, and that would be related to organs or tissues or the brain, for example, and education. So we are able to provide a bit more on the documents that we prepare.
And Carla, I mean, any restrictions on where cremains can be distributed? I know that question comes up a lot. So
Mhm,
want
mhm.
to jump in on that?
Yeah, so it depends on where. There are no restrictions at all on spreading one's cremated remains or a loved one's cremated remains in Puget Sound. In particular, Washington waterways are free and clear for the spreading of cremated remains. If one is wanting to distribute in an ocean, which would be federal land, there are some conditions. The scattering has to be about 3 nautical miles from the shore, and there's a form that needs to be completed with the EPA in advance of the scattering. And I think similarly, there's permission required for national parks and for state trust lands. But for Puget Sound, no restrictions, no advance authorization.
And of course, on private property, that's totally up to the owner.
Absolutely, yeah.
Okay, Kristin, how about any recommendations or suggestions on how to keep property received as a gift or inheritance separate?
Yeah, sure. I have, I think there's kind of 2 parts to that question. When we end up in court trying to prove that something is separate property, there's going to be sort of 2 parts of the evidence. And one is proving that it was in fact separate property at the time it was given or inherited. So that's why I would recommend keeping any kind of documentation you have on the inheritance or wills, things like that, that demonstrate how much it was that was given to you and that when you received it. If it's a gift, it's helpful to have some sort of gift letter. You know, sometimes like a quitclaim deed on a house is not always sufficient unless there's additional documentation to say my intention was to give it to this person solely as their separate property. And then the second part of that is what happens between the time that it's received and when you may or may not end up in court for a dissolution of marriage or termination of a committed intimate relationship. And in that case, I would generally recommend to keep it in a separate account. If it's an asset, if it's funds, keep it in a separate account, preferably in your own name. Again, title doesn't control, but it's a lot easier to prove later if it hasn't been equally accessible to both parties, used for community things, borrowed and paid back, things like that. And then if it is an asset, keeping it in your own name can be very helpful for proving that in the end also. And not using community funds to improve, maintain, those kinds of things. It really is, try to keep it as separate as possible, keep the community in one account and the separate in another.
And I'd just add, working with clients on prenuptial agreements or postnuptial agreements, having them do estate planning as part of that process so that any separate property they have can be put into a separate trust for them, which may be revocable or irrevocable, so that it's clearly documented to Chris.
I agree. Yeah, relationship contracts are obviously the easiest where both parties are saying this is separate. We all agree.
Yeah. So that's kind of a good segue into the next question for Meng on, does establishing a living trust alleviate this issue of separate property, which we kind of touched on, but do you want to elaborate on that, Meng?
Yeah, so in regards to the question from Kristin, does a living trust alleviate this issue by assigning ownership or beneficiary to the LT? And in some circumstances, yes, this is definitely one of the things that people do look to. One great example is if people leverage gun trusts to actually transfer ownership of specific firearm types to a trust and then use the trust as a transfer mechanism upon their passing to kind of bypass the probate of those particular assets. Now, with that in mind, there are certain things that, like we'd still have to identify particular assets as well as transfer ownership. And this is one of the things that I think a lot of people are not aware of, especially with living trusts, is that with when you're transferring assets, if the assets are require specific titling requirements, you do have to retitle these particular assets to the trust to get some of the benefits that Mike touched on earlier in terms of confidentiality of the assets, as well as making sure that the assets are kept up to date and are transferred according to the trust instrument.
Next question is, do different states, US states, treat timeshare interest differently at death? And Meng, do you want to?
So we're not experts on timeshares and other jurisdictions. I'm only licensed to practice law in Washington, but generally speaking, most states do, based upon my experience in terms of contacting different locations within the United States, most states do sit there and treat timeshares interest as regular real property interests that do require transfer via deeds and or probates.
And there are going to be contracts with the timeshare management company that have to be
Correct.
followed as well. A general question about disowning children in favor of other children, another child who may or may not have special needs. And Carla, do you want to touch on that?
Sure. So, I mean, as a general answer, you may provide for or not provide for anyone that you wish under your will. Of course, we've talked about community and separate property. So, a married person doesn't own all of the property to give away, but it is not uncommon, I think, in our practices to see a special needs child being favored in an inheritance plan. And we would look toward a special needs trust for disabled beneficiaries so that they could, if eligible or may be eligible in the future, continue to receive public assistance, income, and healthcare without being disqualified, and also have the full benefit of the assets in the special or supplemental needs trust.
Yeah, and just make a general pitch. That's why wills are so important, because if someone dies without a will, then the disposition of the estate follows our intestate statute, which is a lineal descendant line of how assets are to be distributed, which could involve persons that the decedent hasn't had contact with for many years or would not want to receive their estate. So wills are so important to have to provide for that disposition and protection of assets for a child or a relative that may need some protection, as well as having someone with the authority to administer the estate. Carla, another question on can UW reject receiving a body?
Yes, they certainly can. And there's a number of factors that I understand that they may consider. If perhaps if there is a surplus, they just state generally for any legal or medical purposes they can reject a donation at the time of death. They do provide some specific examples of why they may reject, severe decomposition, severe trauma to the body, certain infectious diseases, and autopsied remains may be rejected. And that's actually on the World Body Information Letter from the University of Washington. But those are some examples of why rejection may occur.
Okay, and then a follow-up question regarding disposition of cremain ashes on someone's own property, and that's absolutely permitted. And then a final question here: will we be sending out the slide deck? And I'm going to let Meng address that.
We will be posting the recording to our website if people would like. Since there are multiple slide decks, we'd much rather just have the recording available, and we will notify all the attendees when the recording is available. Okay.
Okay. All right. Well, thank you. And I want to again thank all of the folks that were able to attend today. And please go to our website to become more familiar with the attorneys who spoke today, as well as our other attorneys and the types of practices that they have and the types of opportunities to consult with them about the types of legal issues that you or your family may be facing or your business may be facing. We're happy to address those issues with you. And Greg, we didn't get to ask you a question. I know Kristin and Meng and Carla all had a question. So any words of wisdoms you want to share as we sign off here on
Thank everyone for coming again. And I think mine was very specific and specific to litigation. So I think if you never have to talk to me, you lived a life well lived. But if something does come up, we are here to help and happy to consult for your needs.
Right. So there may be, working with some clients with Greg on insurance issue or insurance coverage issues or personal injury. Again, as Greg says, hopefully you won't have to talk with him. But if you do have those types of issues, Greg's the person to talk to. Well, I think that's it for today. Thank you so much. We hope to do a webinar in probably another few months on some other topics, introduce some of our other lawyers that are providing services in estate planning and family law, as well as real estate matters and business matters. So we look forward to connecting with you, but please give us a call or send an email if you have any questions in the interim. And thanks all for being here. Have a great day and a great holiday weekend here as we look forward to the 3-day weekend. Thank you.
Thank you, Mike.
Thank you.
Thank you.
Thank you, Mike. Thanks, everyone.